discussion?
Thank you very much. Please be seated. This is a time set for oral argument in Franklin versus Clement, our cause number CV150194. Let's begin with introductions of counsel for the appellant.
David Abney, Your Honor, for plaintiff appellant, and Karen Mogosi for plaintiff appellant.
Christopher Robbins, Your Honor, for defendant Dan Blanchard, and with me is John Barnes for the defendant's commit.
Thank you very much. I know you're both very experienced, but let me just go over a few preliminaries that I'm sure you've already committed to memory. Each side has 20 minutes, so I presume the appellees have decided in advance how they'd like to divide that time up. We are recording the proceedings today, so when you go to the lectern, if you would please restate your name. I'm sure you're aware that the panel has closely examined the briefs. We have reviewed pertinent portions of the record, and we have discussed the case, and we're familiar with the issues and the arguments you have raised today. When the appellant goes to the lectern, if you would like to reserve some time for rebuttal, let us know at the beginning of your remarks, and we'll try our very best not to poach on your time so that you actually end up with the rebuttal time. So with that, let's go ahead and begin.
Thank you, Your Honor. May it please the Court, David Abney for plaintiff appellant. Once again, I'm here about Article 18, Section 5, my favorite clause of the Constitution. I think we're coming up on the 114th anniversary of the adoption of the Constitution, which was in the fall of 1912. And the clause has stood the test of time barely, often by 3-2 decisions, or has been, I think, misconstrued over the years and not defended and protected as well as it should have been. One of the cases that makes me think that is one that my colleague mentioned in his answering brief, Layton versus Roca, which I thought was a fascinating case when I went back and looked at it. Fascinating for what for some things it didn't say and for many things that it did. It was a 1962 opinion where the plaintiff prevailed in a traffic accident case where the court acknowledged that there was fault on both sides. So they disposed of that right away and then got into the problem. The trial court had given an interesting instruction that said, if both parties were negligent and such negligence proximately contributed to bringing about the accident, the law would leave them where it finds them, and the plaintiff may not be entitled to recover, and your verdict may be for the defendant. I like the part about the law would leave them where it finds them. I don't know what that tells the jury so much, but the problem in the case was that the plaintiff won and got $25,000, which in 1962 was a princely sum. You could buy a luxury sports car in 1962 for $10,000, so you got 2.5 luxury sports cars here at issue. And the defense had presented its own proposed jury instruction basically saying that if you find there is any compared contributory negligence, then you must find for the defendant, which is wrong under Article 18, Section 5. But what the Supreme Court did was, in a 3-2 decision, said that, well, this may find is okay. And I think that may have been a reflection of the realities of the case. The plaintiff, after all, won. The two dissenting justices, well, said that, well, you really should have an instruction that says you should find. And in the era before the Uniform Contribution Among Tortfeasors Act, that sort of makes some sense in a way. It was a black and white world at that time. If there was any contributory negligence on the part of the plaintiff under the common law would lose entirely, no matter what the percentage of the contributory negligence would be, except in Arizona. In Arizona, we have a unique constitutional clause, Article 18, Section 5. We stole it from Oklahoma, from the 1909 Oklahoma Constitution, word for word. But within a couple of decades, the Oklahoma courts had killed the constitutional clause, but it said our judges, if we believe that reasonable people could not disagree on the subject of contributory negligence, we're going to go ahead and rule on it, and we don't care what the Constitution says. It can't mean what it really says. Well, in Arizona, it really means what it really says. The constitutional problem with ARS Section 12711 is that it is misleading. It gives the jury the impression that there is something significant about being 50% at fault by the plaintiff, and then you may find for the defendant. But under the Constitution, no. You may find for the plaintiff. You may find for the plaintiff if the plaintiff is 100% at fault or 99.99, whatever, however far you want to take out the digits, is at fault. You can find for the plaintiff. You can find for the defendant if the plaintiff is only fractionally at fault, or even if the plaintiff had no fault at all. That's the genius of the constitutional clause.
Mr. Abney, and I understand your argument. I looked at it a little bit more in terms of your argument was that 12711 is unconstitutional because it invites the jury to focus attention on the plaintiff's conduct and kind of makes the 50% somewhat magical.
It does.
Okay. The concern I have is that we have a line of cases, I think it's Williams, in which our Supreme Court addressed a very similar argument in the context of what is a court to say to a jury when there's evidence that the plaintiff's conduct was willful and wanton. Because under 122505, the statute provides a claimant has no right to comparative negligence if the claimant has intentionally, willfully, or wantonly caused or contributed to the injury or wrongful death. And the Supreme Court, resolving conflicts in the Court of Appeals, approved a particular jury instruction that allows a trial court to provide permissive language with respect to wanton, willful, and wanton. So with that line of cases, how do we then square your argument with that authority?
Well, Article 18, Section 5 specifically addresses contributory negligence. If you start getting into intentional conduct or conduct that is so extreme that it can be equated with intentional conduct, you're not talking about negligence anymore. You're talking about something with intent. Once you do that, Article 18, Section 5 probably does not apply. And here we were talking about negligence. If you take their version of the facts, we had a drunken, out-of-control person instigating this whole series of events. Sort of hard to square that with intent if you're drunken and out of control.
Well, we have case law, admittedly, it's in the criminal context, that being intoxicated does not necessarily negate a voluntary act.
No, it doesn't, but it does muddy the waters as far as what you're dealing with, negligence or intent. And there was never a claim here of intent. This has been a negligence case from the start. Mm-hmm. And so the defense is you were contributorily negligent. And in the parlance after Uniform Contribution Among Tortfeasors Act, that you were comparatively negligent. Our courts are equating contributory negligence now with comparative fault. And the long and short of it is, if you get an instruction like this, then to shift a little bit, you get into problems with UCADA, because UCADA requires the jury to look at the entire situation and apportion fault among all those who may be at fault for causing the event. Here, I don't think there were any non-parties at fault. So you got the defendants, you got the plaintiff. If you said it's 50% at fault, plaintiff, well, then under UCADA, the jury doesn't get to say, okay, defendants, you get a pass, you're done, and you're not liable at all. No, the jury is supposed to be saying, well, okay, there's 50% of the plaintiff. What do we do with the other fault? It's 50% goes to the defendants, 25, or 35-15, or however you want to do the math for the plaintiffs. But the 50% fault that's floating out there doesn't go away. But suppose you say that the plaintiff is 90% at fault. Well, there's still 10% of fault to apportion to somebody else, and it's going to be, in this case, since there's no non-party at fault, it's going to be to the defendants. So if you apply the statute, it not only, I believe, is an unconstitutional invitation to the jury and a misapplication of constitutional principles, it also violates UCADA. It gets you in very deep water with UCADA, because the jury's not supposed to be saying, I find somebody 50% at fault, I'm done, let's go home. We can just find for the defendants and that's it. No, there's more that has to go on there. Part of the problem is, and I try to do as much appellate work as I can, but occasionally I get stuck going to trial and trying to help out. What impresses me, and I'm sure it impresses you, but with your experience on the bench, is how much juries really rely on jury instructions. I mean, they parse them. They'll send questions back to the court and counsel about what does this instruction mean, and you can tell that they agonize. This is their roadmap, and in part, it's so important because we don't have professional jurors in our nation. And as part of the voir dire process, it seems to me that people who have prior jury experience are often among the first on the chopping block. They don't get back into the panel because somebody said, well, that person's going to be a leader and that person's going to influence the jury because of what they did in a previous case or how the previous case turned out. But these instructions are vital. It's not just a theoretical discussion among judges and lawyers. They have a tremendous impact on how the case is decided. Now here, nobody knows, of course, exactly what happened. The trial judge, in a minute entry, where he was discussing the weight of the evidence, but the trial judge also made some comments about what had happened. And he said the jury could have reasonably found, one, defendants proved their affirmative defense, that as a result of plaintiff's intoxication, he was at least 50% responsible for the incident, thereby allowing them to find defendants not liable. One. Two, or the jury could have found that plaintiff was 100% at fault because he assumed the risk of injury under the circumstances. And I think there's other variations you could have there too. But those are the two that occurred to the trial judge. And that's Index of Record 483 at page 4. 483 at page 4. This, I submit to the court, this instruction had a profound influence. If a reasonable person reading this would take it to heart, would worry about influence from intoxicating liquor, which isn't defined, would worry about trying to figure out 50% at fault related to not the overall event, but to the intoxication. It ties right into that as far as responsibilities. It's intoxication-related connection. And then once they say, okay, we'll say 50% because of the influence, 50% at fault, and then boom, let's just find for the defense and we're done. And that's not the way this should go under the state constitution. I briefed pretty heavily, and I hope, okay, the malingering problem. You know, when you have an expert saying that somebody's a malingerer, the expert's saying the person's a liar, that they're faking their symptoms. Once that gets into your noggin, hard to get it out. Here we have this expert saying we've done these scientific tests and we've established this person as a malingerer, and he's faking the symptoms, which is the person's a liar. There should be other ways to approach this from an expert viewpoint, that the symptoms are inconsistent with actual injury. You don't have to go into this malingering kind of thing. And I would like to stand on my briefing on that because I don't know if I can really say it any more or less eloquently than I've said it. And the last issue, every time I tried going over this last night, I found myself like I was talking in double entendres. I don't want to touch this. This is my ending argument. The plaintiff was the butt of the joke. I mean, it just gets ridiculous. But to have this sort
on that one too.
Yeah, well, but to have this sort of thing put into the trial, you just don't need it. It makes people, it makes me uncomfortable, and it's not, well, I don't know. It just bothers people, and to some extent. Not everybody, sure, but why do it? When all you had to do was to say, you could stipulate that that there was no, well, actually, the plaintiff backed away from this, no pun intended, backed away from this at the conclusion, and didn't want to have this in at all. They dropped all claims for any sort of sexual dysfunction or any sort of sexual problems. Well, why get in? Why get into this at all? There's no need to.
Wasn't Mr. Franklin still pursuing damages for basically a diminution in the quality of his life?
I suppose, but you could certainly say, but you were still engaging in sexual activities. Or there could be a stipulation that he was still engaging in some sexual activities. You don't have to have this at the very conclusion of the evidence. This is the very last thing. It's very slick lawyering, very adroit to get this in, and then they rest, and that's it.
His own physician, though.
Well,
and
yes.
The trial judge, who is a she, by the way, but saying he.
Yes.
required the parties to use the phrase sexual relations.
Yeah, but what actually came out in the
From his own
transcript,
physician.
right? But what actually came out was the actual word anal sex, and it's right there at the
That's true
end.
because of the deposition was taped and
Right.
presented to the jury, but
And you don't have to. You could edit that out. We do it all the time.
But let's assume that that should have happened. What can you show us in the record where there is demonstrable prejudice from that?
Oh, I can't.
Yeah, that's the
I
problem with
cannot.
that argument, isn't it?
It is a problem, but I don't think it's an overwhelming problem because this is just so over the top. But why have it in? Now, I don't know how much prejudice it caused. Certainly would cause some, I would think. I submit. I can't prove it.
well, if we.
But it's.
But isn't that the problem here with our standard of review? You know it as well as I do. You just heard the other argument.
Right.
We weren't there.
Right.
The trial judge was there, heard it all. It was mentioned. She instructed the parties, don't refer to the specificity of the act. Just talk about sexual relations. This was an 8 or 9 day trial.
Right.
And in order to show that the evidence was improperly admitted, there has to be error, but it also has to be prejudicial. And we are just,
Well, here's what I have to say about that. There are some things that are just so bad, over the top, they should never be in the trial, and this could have been easily removed from the trial. You can either edit the videotape or just don't play that part and stipulate.
I do not recall, forgive me, and I can go back and look, but I do not recall the trial attorneys here specifically saying, Judge, we can edit this out because this was, whatever edits were to be made should have been made much earlier. And the judge, I believe on the record that we do have, expressed considerable frustration with the last minute changes in what was going to be played to the jury and what was going on. And I think that perhaps played into all of this. I mean, is there some place that you can point me to in the transcript or the record that we have in which there's some type of evidence that there was plenty of time to edit this out?
I have fallen astray. As far as the editing part, that was a suggestion of what could be done. The better suggestion is simply not do it at all, which the plaintiff certainly asked for repeatedly. Don't get into this. That we withdraw our claim of sexual dysfunction. Do not mention this. Do not get
But you
into
still-
this.
but
And the
Mr.
trial judge
Franklin
said,
still-
okay.
I'm sorry, I didn't mean to interrupt. But Mr. Franklin still had claims for damages for the impairment in his quality of life. So
Oh,
it
sure.
all kind of,
But you can deal with that by saying, you don't have to say he can't do some Kama Sutra act or any particular sexual act. You don't have to mention what the act is. Just say that he can or cannot still engage in sexual activity. I'm hoping there'll be a remand. And if there is, perhaps the court could say this is not really the thing to get into, as a secondary kind of issue, even if it's not enough in itself, although it may be. To require a retrial, but it's just not a good thing to be doing, and it could have been avoided entirely, and the jury could have gone to civil relations without that thing resonating in their ear, which is not the way you'd like the jury to go to the jury room. Thank you. No questions. Thank you very much.
Good morning, Your Honors. Christopher Robbins for Defendant Dan Blanchard, and I'm with John Barnes, attorney for Defendants Clement. Before I begin, I'd like to call the court's attention again to one mistake that was made in the reply brief. At page 18, they cited section 12-712B, which follows this statute we're interested here, and also Sonoran Desert Investigations. That case analyzed the old mandatory language of the statute. It has nothing to do with this. 712B has now been amended to have the exact same permissive language as the statute we're interested in here. One other concession, which sort of follows along with some of the questioning earlier, is on page 13 of the reply brief. They inadvertently concede the instruction issue. Twice they say essentially the same thing, and I'm quoting, "In the final analysis, no one can definitively say what impact the jury instruction had." And that's the exact problem here, is nobody can say there was any prejudice as a result of that instruction.
But we have plenty of case law that if the jury is improperly instructed in violation of Article 18, Section 5, it doesn't matter whether the jury could have decided it on a different issue. The instruction is deemed to be reversible. And so that is the argument, as I perceived, that Mr. Abney, on behalf of his client, was making. And even if, let's say hypothetically, we agree that we disagree with the merits of his argument, we don't find a violation of the Constitution. Nevertheless, he is posing the argument that the instruction does violate that section. So then wouldn't we should be addressing it, which is really the essence of his argument. We have case law that suggests that.
Then let's move right to Article 18, Section 5. Your Honor, the statute is entirely permissive. And all of the case law that we find out there, I remember that there was a contracting statute that was mandatory. You had to dismiss in this situation. The old criminal statute about intoxication that we just discussed, you had to dismiss. The court said that is unconstitutional. When it's permissive, it's not, because the jury retains the right to do whatever it wants to do. It could find that plaintiff was 100% at fault, still return a defense verdict. It could find the defendants were 100% at fault and still find in their favor. It could find anywhere in between and resolve the question in either party's favor. The jury is 100% the one with the discretion. We talked a little bit about why the 50% figure. Well, there was a sound public policy for that. The legislature doesn't want people to be under the influence and hurt themselves or others. Doesn't want to reward people under the influence if they get hurt. If the question here is back about the statute, then Mr. Franklin's remedy is to go to the legislature and amend the statute. It's not unconstitutional just because he doesn't like it.
Mr. Robbins, you heard my question to Mr. Abney about distinguishing or not distinguishing the Williams case. He attempted to distinguish it by explaining that in Williams, the court was wrestling with whether I think it was 122505 violates the Constitution. And he said, no, that's distinguishable because that really is dealing with close to intentional conduct. What's your response to the way he distinguishes Williams?
I profess, Your Honor, I'm not quite sure I understood. UCADA, of course, always tells the court to apportion fault. Again, sort of backing up to what I was saying earlier, we don't know what the jury did here. We have no idea what the jury did here. And we'll never know because we can't none of us can read the minds of the jurors. There might have been solutions, maybe a special jury verdict form or a special interrogatory saying, did you find that Mr. Franklin was under the influence of alcohol? Did you find, what percentage of fault do you attribute to him? Mm-hmm. We might have had answers, but we don't. And if they intended to raise this constitutional issue, the time to have thought about that might have been at that stage of the ballgame.
to follow up on Judge Norris's question, what if we were at that stage of the ballgame? Let's say we're here on a special action. It's hypothetical. The question is, does the jury instruction that was given in this case withstand constitutional scrutiny? And you've heard your adversary's view on why Williams doesn't apply. What would your response be?
Back to the idea that the legislature can always regulate any of these things, and for sound public policy reasons, it didn't choose 5%, it didn't choose 90%, it chose 50%. The legislature ruled, and the judge simply followed the law. The judge instructed on the law as it is.
What if instead of using may, the legislature in that context used shall? Same answer or a new problem?
I think that moves into a very problematic, because shall we usually think of as mandatory. And if the legislature is telling the jury it has to do something, that is absolutely unconstitutional. But it didn't. It said may.
And there's no argument that it did, so let me not take us down a rabbit hole. But with respect to Williams, your adversary says, well, wait a minute, that's intentional or quasi-intentional conduct, therefore that whole line of cases, if there is a line, doesn't apply here because we're talking about pure negligence. And there's no claim that there was an assault or an intentional conduct here.
Well, originally there was a claim, but
for purposes of today, right? And intentional conduct, at least for today, the view was doesn't fall within the purview of 18 Section 5, but negligent conduct does. So what's the answer there?
Well, the answer is always that it allows the jury to do exactly what juries are required to do under Article 18, Section 5, which is always, as a question of fact, in every case, they determine contributory negligence and assumption of the risk. The jury was allowed to do that in this case. The jury, they could have argued anything they wanted. The jury was permitted to do anything it wanted. And if I can turn back to Romero for 1 second, a case that we haven't cited yet, but which has already addressed this particular statute and an instruction based upon it. It's true, as Mr. Abney pointed out, that Romero found a lot of issues waived. But this is what it said regarding the argument regarding Ukata and implicitly Article 18, Section 5. This argument on its face appears to lack merit given the permissive language of Section 12.711. And I'm reading from, it's 204 of the opinion. We've been down this road before in case after case, and what the courts have said is when the jury is still permitted to do what juries are always permitted to do, there's no constitutional infirmity. We never touched on any of the other arguments regarding whether the statute is constitutional or not, and I don't know if your honors are interested. I mean, we're certainly willing to stand on our briefs. Article 18, Section 6 was directly addressed by the Romero Court, and they said no, it doesn't abrogate a cause of action. And in fact, Mr. Franklin, not only was he able to pursue his cause of action, but he pursued it all the way through verdicts. He had his day in court, which is the basis for that provision. They mentioned in their briefs that the jury can wreck a plaintiff's case. Well, the jury is always going to wreck one party's case by ruling in favor of the other party. The vagueness argument, the case law and common sense just tell us that under the influence, we all know what it means. The cases talk about the slightest degree. A recent Court of Appeals opinion, State v. Martin, talks about to the slightest degree. There's no vagueness problem here. The statutes, you don't have to define every term. There are commonly understood terms. Talking about what Mr. Abney characterized as the malingerer issue. Mr. Franklin asserted a long list of alleged injuries, some of them neurological injuries. Defendants had an absolute right to call an expert to defend against those claims. Dr. Susan Borgano administered a number of psychological and neurological tests looking for consistencies between the alleged symptoms and what neuropsychologists expect when they see the tests. In other words, if there are neurological injuries, were they caused by the incident at the hockey game, or were they caused by something else? And she found inconsistency after inconsistency and concluded that Mr. Franklin had not suffered neurological injury, but rather those symptoms arose from some other cause. She did not question his credibility. She drew a medical conclusion from the test results that he was malingering, which is entirely common. It happens 40 to 50% in lawsuits. Mr. Franklin's counsel ably cross-examined her, very ably cross-examined her, and they offered their own expert on the exact same issue.
Well, that's only after they lost the motion in limine, isn't it?
Yes.
So, I mean, they didn't open the door.
Okay. They did, but the point is that this became a battle of the experts, just as in the case of State v. Thornton, which we cited in our briefs. The jury agreed with Dr. Borgano, and so the question all along was the weight to be given to her testimony and not its admissibility. Defendants are always permitted to defend against the plaintiff's claims, and that's simply what she did here. I think we've resolved the third issue, and I don't necessarily need to say anything additional. There's nothing wrong with the testimony. This trial occurred in Arizona in October 2014, not in biblical times. So I always appreciate Mr. Abney's scholarship, but page 29 of the brief is...
Did you find that site that he had? I wanted to ask him about that, how you found such an obscure law review article that I was compelled to read. Just,
Diligence, Your Honor.
is that what you're referring to? That was the most remarkable thing.
And Leviticus. You know, there was he admitted there's no showing of prejudice here, which you need to show both error. There's no error. You need to show prejudice. There's no prejudice. It's true that by the end of this trial, the jury, I don't think, liked Mr. Franklin very much. But it was not because of two words said on a videotape by Mr. Franklin's doctor. It was because the night of the hockey game, he was loud, obscene, obnoxious, drunk, and a bully. That's why the jury returned the verdicts that it did. So unless the court has further questions, we ask the court to affirm both jury verdicts and both judgments.
Thank you. Thank you.
I would first like to thank my colleague for his, as always, sterling presentation. It's a pleasure being in courtroom with him. If there are no specific questions, I have some closing comments, and I can sit down. We can go to lunch. In 1910, in the fall, the Constitutional Convention met. One of the leaders of the convention was Albert Cornelius Baker, who had just an incredible career. He was a judge on the Territorial Supreme Court. He had been an extremely successful plaintiff's lawyer. He represented unions at a time when unions were incredibly unpopular. He was down in Bisbee a lot. You'll see his mentioned in newspaper articles in Bisbee, trying to help out the miners there before they got deported and after. Just an incredible gentleman. He appeared on the Constitutional Convention. He was an elder statesman by then. And later, I think it was 1919, he was elected. Back in those days, it was just a straight election to the Arizona Supreme Court. He was one of the people who pushed hard for Article 18, Section 5 for its adoption. And then in 2 or 3 opinions around 1920, the year before he died, he wrote about the impact of the clause. There had been some people who wanted to confine it to the labor because that's where it appears in the Constitution. He says no. Its plain wording means that it applies to all personal injury actions of any kind. And if we had intended something else, we would have said something else, paraphrasing slightly. But that was his view of it. And his words still live on. It's an incredibly important clause. In 1910, the world of 1910 was, we're in the middle of the progressive era. So many wonderful changes had happened already. The Food and Drug Act, curbing the monopolies, the Good Roads movement, the Good Nurses movement. There's so many movements going on. The ABA was established, I think, around 1909. Just an incredible ferment. And one of the things that Arizona placed firmly into the trash can through Article 18, Section 5 was this notion that judges can destroy cases because of a comparative contributory fault and assumption of the risk. No longer. It was going to be solely for the juries. At all times, the words are just incredibly strong. In all cases whatsoever, and at all times, it's left to the jury. Here again, we're with Article 18, Section 5, and I urge the court to find that the statute is an unconstitutional invasion of the jury. It's a misdirection, miseducating the jury about what their incredible discretion is. They can find for anybody they want, in all cases whatsoever, and at all times. And I thank you, and I think Albert Cornelius Baker may be thanking you soon, I hope. Thank you.
Well, thank you very much, counsel. We appreciate your argument. We appreciate your briefing in this difficult case. We will adjourn, issue decision in due course. Thank you.